afternoon, everyone. Hi, everyone. I'm Doreen. I'm very pleased to be here, and we have a very fascinating panel today with Levi Cooper and Joseph David. Want to sit next to me, please? Okay. So Dr. Levi Cooper researches Jewish law in the late modern period, in particular amongst those associated with Hasidim. His doctoral dissertation, the Admiral Rabbi Chaim Elazar Shapira of Monkas, the Hasidic Posek, Image and Approach, was completed in the faculty of law, Ilan University, under the supervision of Dr. Itzhak Brand. He lectures in Jewish law in the Pardes Institute of Jewish Studies in Jerusalem. Welcome.
Thank you.
And Professor Joseph David is a senior.
We seem to have a technical problem.
So I can continue in the time, I suppose. A senior lecturer of law and religion in the Hebrew University of Jerusalem in the Sapir Academic College, the author of many books, and the latest among which is Between Logos and Nomos, Law and Theology in Medieval Jewish Thought, that is forthcoming or is already out?
Well, yeah, there's another forthcoming next month.
Okay. Wonderful. Okay, so we're not keeping pace. Okay, so welcome.
Thank you.
Just a second here. That's it?
Yeah. Good afternoon. Cantor Yossele Rosenblatt, as he was affectionately known, was offered a chance that would make any performer swoon, a star role in the landmark film The Jazz Singer, a film that ushered in the age of the talkies. Yossele refused. The lucrative offer, which would have provided much-needed financial security, did not succeed in coaxing the great Cantor to take the role. This paper contextualizes the legend of the Cantor's baffling decision. In order to understand Yossele's alleged refusal, I'll explore one vector of the multifaceted interface of Jewish law and the art of storytelling, namely when law and storytelling present parallel paths to a common end. The possibility of parallel paths is particularly significant where law is incapable of organizing society and alternative media are needed to provide order. This interface between law and narrative will be refracted through the particular lens of liturgical performances outside the synagogue service, specifically the propriety of cantorial concerts of liturgy from the High Holy Days. In artistic terms, the issue is whether cantorial recitals are site-specific. Site-specific art emerged in the 1970s, first as visual arts and later on as performance art. And admittedly, the use of the term in the cantorial context is chronologically misplaced and expands the parameters to refer to art that is created to exist in a particular time, namely the High Holy Days, as well as in a particular place, namely the synagogue. Storytellers and jurists grappled with the phenomenon, each modality using its own tools to declare that cantorial liturgy was a site-specific art form. Storytelling is an orally aesthetic and evocative art form. Storytelling was embraced by Hasidism, a Jewish religious movement that began to take form in Eastern Europe in the second half of the 18th century. In the Hasidic milieu, storytelling has had a variety of purposes. For my discussion today, I'm interested in the pedagogical, andragogical, and norm-generating potential of Hasidic tales, because this vector intersects with features of law. The decentralized nature of Hasidic leadership gave rise to a plethora of leaders, each ministering to a particular locale, primarily in Eastern Europe. One such master was Rabbi Yitzchak Isaac Taub, who was active in the northeastern Hungarian town of Nadi Kalo, or Kaliv in Yiddish. It's imperative to point out that the present study focuses on the Hasidic tale as a medium for inculcating behavior. As such, the tale's historicity is not critical. Hasidic tales describe Taub's cantorial dexterity. One such tale was recounted in early 20th century Mukachevo in Czechoslovakia. According to the tale, Taub was travelling through the Hungarian countryside during winter, collecting money for the needy. During his travels, he lodged at the home of one of his disciples who was excited that he had the opportunity to showcase his teacher's cantorial dexterity before his wife. The wealthy disciple offered Taub a deal. Taub would perform a central and moving liturgical piece from the high holidays, and in exchange, the wealthy disciple would donate the entire sum that Taub sought to raise. Taub considered the offer, but declined, explaining that when he sang the High Holy Day prayers, he would actually convene the heavenly court. I quote in translation, "And when I say the words, and the angels scurry, the angels really tremble, and they will ask one another, 'What is this? What is this commotion and trembling now?' And they will say, 'Isaac needs money.' And the angels will say, 'Oi, for money he troubles us and causes us to tremble so.' And I too will be embarrassed before them. So for 300 coins will I trouble the entire heavenly court to tremble? Therefore, I must stop myself from doing this, and heaven forfend that I should do such a thing." The Hasidic allegiance, hearing or later on reading the tale, would not have thought that only Taub's powerful prayers must be reserved for the appropriate context, and that a mere layperson can perform the liturgy without regard for the forum. Such a reading would reflect a misunderstanding of the genre of Hasidic tales. The Hasidic allegiant hearing the tale in early 20th century Mukachevo, the golden age of cantors, would have understood the norm. High Holy Day liturgy was site-specific. From the 19th century onwards, some Hasidic masters also served as jurists. One example of this phenomenon was Rabbi Meir Horowitz, Hasidic master and official rabbi in Jikov in Galicia. In an undated responsum published posthumously, Horowitz was asked, I quote, about the custom to sing certain psalms when celebrating a new month, a day considered to be a minor festival. The anonymous questioner noted that singing songs at a meal was in contravention of Jewish law, unless those songs were specifically mandated by tradition. The questioner understood that since the destruction of the Second Temple in the first century, Jewish law forbade singing at meals as a public expression of mourning. The only songs allowed at mealtimes were those that had been instituted from time immemorial, such as the songs traditionally sung at the Sabbath table. Other poems were forbidden. Horowitz's responsum was definitive. There's no such prohibition. The prohibition that appears in earlier sources, explained Horowitz, applies to two cases. First, songs that were not connected to God, such as epics, ballads about beauty, or love songs. They were forbidden because of their content. Second, songs whose content was not problematic, but they were simply out of their appropriate context. Horowitz illustrated the out-of-context prohibition by referring to cantors who sing High Holy Day liturgy at festival meals for the entertainment of those sitting around the table. Like Taub, Horowitz concluded that cantorial recitals were site-specific. Yet, unlike Taub, Horowitz's position was based on an interpretation of legal sources and consideration of historical precedents. The Jazz Singer was the first feature-length motion picture with synchronized dialogue. Legend has it that Cantor Yossele Rabinowitz was asked to play the role of Cantor Rabinowitz, who berates his wayward son on the eve of Yom Kippur, the Day of Atonement. The son runs away from home, and as Cantor Rabinowitz stands at the synagogue lectern, he says, "My son was to stand at my side and sing tonight, but now I have no son." He then launches into a soulful rendition of Kol Nidrei, the solemn prayer that opens the services of the Day of Atonement. In his 1954 biography, Samuel Rosenblatt, that's Yossela's son and a long-time congregational rabbi in Baltimore, recalled that his father declined the offer despite his financial woes. According to Samuel, Yossela explained to the agent of the Warner Brothers that he was against acting, quote, whether it be on the screen or the stage, noting that, I quote again, "In order that my face might be photographed well, I would have to use makeup, and that is definitely out of the question." The agents tried a different tact. "We see that we can't make even a bit of an actor out of you, Mr. Rosenblatt, but how about just letting us have the use of your voice without your being seen in selections, say, like Kol Nidrei?" Samuel recorded his father's indignant response. "Did you say Kol Nidrei? That hallowed prayer that is chanted by the cantor at the inauguration of the holiest day of the year? Under no circumstances would I permit that to pass my mouth anywhere except for the house of God." Samuel's account is often cited, though it is patently flawed. Like other cantors of his day, Yossela had no qualms about sound recordings of prayers. In fact, cantorial recordings, despite being thrice removed from their original forum, space, time, and intent, were not looked at askance. Yossela was no exception, recording Kol Nidrei 4 times. The producers of the jazz singer apparently still wanted Yossela for a cameo role. Here too, Samuel was confused. I quote, "My father agreed, provided he was not photographed to sing Rachem and several other non-liturgical Jewish melodies." Yossela did appear in the film as himself, in a concert setting, singing a Yiddish song. This was not Yossela's only screen or stage performance. The great cantor appeared in concert, vaudeville, and philanthropic performances, as well as a number of short films. Let me say, I have found no contemporary evidence to support Samuel's claim that his father was actually offered the star role. Nonetheless, Samuel's flawed account has been etched in cantorial memory. Samuel, therefore, became the storyteller as he related the feats of the master, not the Hasidic master, but the cantorial master. In concert with Yossela's celebrated piety, he refused a financially and artistically lucrative offer. Kol Nidrei belonged in the synagogue, not on the silver screen. The mystic, the jurist, and the cantor, each critiqued out-of-context cantorial recitals. Each critique, however, was voiced in a different timbre. A captivating Hasidic tale that evoked mystical perception, a reasoned legal opinion, and a cantorial tale of American acculturation that depicted a cryptic refusal to perform. Grouping these 3 cases under one rubric is particularly important in the context of modern Jewish law, a legal system that has lacked effective enforcement mechanisms. Certainly in late modern Europe, no writ of execution could be used for litigants who chose to ignore an award against them in Jewish law. In Hasidic Europe, tales of the escapades of Hasidic masters who were endowed with mystical dexterity might have had a greater impact than a learned legal opinion. Similarly, in 20th century America, a courageous decision of a hero who straddled the old and the new world might move hearts more than a rabbinic directive. The evocative element of the arts, in this case, tales of Hasidic masters and tales of cantorial virtuosos, was a possible counterpart to the emasculated state of Jewish law. Shulamit Almog has described the phenomenon of literature alongside law, where the two cultural creations complement and supplement each other such that they are linked but devoid of hierarchical value. My analysis of the responsum and the Hasidic tale suggests expanding Almog's paradigm to art forms such as storytelling. To be sure, access to a particular Hasidic tale might be via its later literary form, as in this case, but we must remember that its original and most captivating medium was as an oral art, not as a great work of literature. Non-legal systems play an important role in achieving social order. Thus, the parallel relationship described here may have broad implications, in that art forms might be a salve when legal enforcement mechanisms are stymied. Societies where the arts reign supreme, or at least are seriously considered, may be able to solve disputes while avoiding certain costs, such as those that executions of judgment impose. Robert Ellickson has written on what he called order without law that develops within a close-knit community. I'm suggesting that order without law can be grounded in the social sway of art in a close-knit community with shared values and norms. Bereft of effective enforcement powers, the Hasidic milieu embraced the intracommunal activity of storytelling in a bid to guide behavior and shape life when it was beyond the reach of law. If storytelling was an effective fashioning agent, then other tools that were more drastic, coercive, violent, and often less effective, such as public censure or communal bans, could be avoided. So too the post-World War II American Orthodox rabbinate. The useful myth of Yossela's refusal, presented in an ostensibly biographic narrative of a cantorial hero, could reach a wider audience and would have a greater impact than a rabbinic directive that Rabbi Samuel Rosenberg may have delivered from the pulpit of his Baltimore synagogue. The evocative nature of storytelling makes it an alternative path for steering society. Art is culture specific, and different societies will favour different forms. Music in the second half of the 20th century, for instance, was often associated with protest and had a revolutionary or antinomian spirit. At times, the path of art runs parallel to that of law, and at times, the two media will seek to encourage different types of behaviour, perhaps competing with each other for hearts and minds, perhaps colliding. As legal historians, we focus on law. Besides law, there are other forces that are also earnestly trying to guide individuals' conduct and society's direction. Those other forces may inhabit the same nomos, may subscribe to the same meta-narrative, but they are not umbilically connected to law. Art is one of those forces, and in the Hasidic milieu, the prevalent art form has been storytelling. Thank you.